Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with Ms. Brady, Ms. Higgs, and Ms. Nelson, and the people are represented by Mr. Edwards, Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. We are outside the presence of the jury. Let's talk about the Phase 3 introductory first. If we can. The record should reflect that the prosecution did their introductory instruction time ago. The defense up in this phase, but I'm not sure. It or
instructions, Your Honor. That's our primary concern.
All right. Does that take care of the concern on behalf of the people?
That's fine, Judge.
Okay. What else?
The instructions as you are instructed, there are two types of aggravation.
Yes, I think it's number 5.
In the second paragraph, it says the second type of aggravation on one hand and the aggravating circumstances on another. We don't have any objection to the language that is there currently, but that might be a better way to say it.
So take out the non-statutory?
Yes.
The reason I left it in is that's how the Supreme Court talked about it in Dunlap, and that's People versus Dunlap, 975 Pacific 2nd, 723, Colorado Supreme Court, 1999. It's the Dunlap opinion that was authored by Justice Corliss. That's how the court referred to this type of evidence. And the other reason I like it is because it distinguishes it more from statutory aggravating factors. So not only are we changing the word factor, but we're also conveying to the jury that this is not part of the list of factors, aggravating factors listed in the statute. These are non-statutory aggravating circumstances. But what's the defense's position with respect to that request?
Your Honor, we have a very lengthy objection to make regarding this entire instruction. So we object to the jury being instructed on aggravating circumstances in general. And I can explain all of our objections to that instruction now or wait until we go through them one by one on the defense, from the defense side. But we object to that instruction in general. So.
Okay. All right. Anything else, Mr. Edwards?
No, Your Honor. Thank you.
Okay. All right. On behalf of the defense, let's go in order, in the order in which the instructions are.
So with respect to the first instruction, Your Honor, we maintain, again, the arguments that we've made at previous charging conferences regarding the issue of merger.
Do I refer to that issue here? Let me see.
Well, it discusses the fact that the outcomes of the first two phases of the sentencing hearing do not in any way require you to vote to impose a death sentence on any of the counts of murder in first degree. We maintain that that should be conviction and not counts, and that the counts should have merged into one conviction for each victim.
Okay. I incorporate by reference my rulings and comments with respect to that issue. What else?
And then the second request that we have with respect to that first instruction is to include a sentence at the end of the first paragraph that reads, under the law, a life sentence is always an appropriate and acceptable verdict. So that would come immediately after a death sentence is still never mandatory or required by law. We think a sentence conveying that message or sentiment to the jury is required by the 8th Amendment as well as Article 2, Section 20 of the Colorado Constitution, as well as the state and federal due process clauses of those respective constitutions, to make it clear to the jury that a life sentence is always an appropriate and adequate verdict for them to render.
Mr. Edwards?
It's our position that that paragraph that ends the death sentence is still never mandatory or required by law sufficient.
And what's your specific position on the request to add that sentence that was just read by Ms. Nelson?
We object to it. Thinks it's redundant of the sentence before.
I don't think it adds anything, and The other issue that I have with it is that if the jury follows the court's instructions, a death sentence is also appropriate, depending on how they vote. If they follow my instructions, which say it has to be unanimous and it has to be beyond a reasonable doubt. If they are all unanimously convinced beyond a reasonable doubt that death is an appropriate sentence, then death is an appropriate sentence, and the law would recognize that. So I have to be careful when I instruct the jury and the law to be neutral and not to convey to them that somehow I have a position on this. I don't. I can't have a position on this, and so I don't think it's I don't think it's helpful. Number one, and number two, I don't think that that's the only adequate or acceptable sentence that there can be, assuming that the jury follows my instructions. So that request is denied. Should we move on to the second instruction, Ms. Nelson?
Yes, Your Honor.
Okay. What about with respect to the second instruction, which starts out with, in phase 3 of the sentencing hearing?
Our first request, and this is a global request, that each time the jury is being told, each of you will be asked to individually decide whether or not you are convinced beyond a reasonable doubt that death is the appropriate sentence. It should read that death is the only appropriate sentence. Our position is that the Eighth Amendment, as well as Article 2, Section 20 of the Colorado Constitution, and the heightened standards of reliability required in capital sentencing proceedings require that it be the only appropriate sentence before a jury can impose the death penalty.
All right, Mr. Edwards, and if you would, I'm being told that apparently they can't hear you, so if you would speak right into the microphone, please, or switch to a different mic.
We would object to that as well. The statute says appropriate sentence. This is a phase where the jury determines an appropriate sentence.
I agree. That's what the statute says. That's what the law says. It doesn't say only the only appropriate sentence. It says the appropriate sentence. So I'm going to stick with the way the instruction reads in that regard. Do you have anything else with respect to this particular instruction, Ms. Nelson?
We do, Your Honor. Our next objection pertains to some issues that we've discussed at previous charging conferences regarding the following sentences. The exercise of your individual reasoned moral judgment must be based on the evidence and information presented during the trial and sentencing hearing. Each juror may consider mercy for the defendant, but mercy must be based on the evidence and information presented during the trial and sentencing hearing. We maintain our objections to those sentences pursuant to the objections that we made at previous charging conferences, that the individual reasoned moral judgment as well as mercy need not be based on the evidence and information presented. And we would also request that the court instruct the jury that mercy alone can be a sufficient basis for a life sentence or a reason not to impose a death sentence, and cite to People v. Davis, Gregg v. Georgia, and Barnes v. State, which is the Georgia Supreme Court case that I cited at the most recent charging conference that we had.
Mr. Edwards?
Your Honor, this argument has been made before, and we would just stand on our arguments that we've made before.
What about the last part of the request, which is to inform the jury that mercy alone can be a sufficient basis for a life sentence or a reason not to impose a death sentence?
I'm not sure that's necessary. The jury has determined an appropriate sentence based upon all the factors, the aggravating circumstances, and the mitigation.
In terms of the first part of the request, Ms. Nelson, I stand by my previous rulings. And again, as I've stated before, I'm not wedded to the specific language that's used here, but somehow I believe I have to convey to the jury that they can't just consider mercy in a vacuum, separate and independent from the evidence and the information presented in the case and my instructions. And similarly, I don't think the jury can exercise, or that each juror can exercise his or her individual reason moral judgment in a vacuum, separate from and independent of the evidence presented and the information presented here and the instructions of law that I provide. So it has to be, both of those concepts have to be anchored in the evidence presented and in the information presented, as well as my instructions of law, but specifically the evidence and information presented during the proceedings. So I incorporate by reference my rulings and comments with respect to that issue. In terms of the request, the last part of the request, to tell the jury that mercy alone can suffice for a life sentence, or for a decision that a death sentence is not appropriate. What I believe the law says is that each juror can consider mercy in making their decision. So as each juror exercises his or her reasoned moral judgment, each juror can consider mercy, and it's not up to the court to tell the jurors whether how much to consider mercy, whether a little bit or a lot of mercy, or something in between. They can consider mercy, and I'm not putting any limits on that. It's up to them how they consider mercy, as long as it is anchored in the evidence and the facts presented in the proceedings, as long as it is based on the evidence and the facts presented in the proceedings. And I think the rest of that, in terms of the request, it may be appropriate for closing argument, but I don't believe that it is necessary in the instruction or appropriate in the instruction. So that request is also denied. What else do you have, Ms. Nelson, with respect to this particular instruction?
Your Honor.
Yes.
With respect to that mercy issue, the court doesn't find is not inclined to give the sentence or add the sentence that I proposed. We're just going to brainstorm a little bit and see if we can have an alternative that might be acceptable to the court. Our next request would be to add each of the jury's final sentencing verdicts must reflect a profoundly reasoned moral response to the defendant's background, character, history, mental illness, and crimes. That goes along with the way that jurors were instructed on mitigation in Phase 2. I believe that mental illness or mental health was specifically mentioned in the definition of mitigation.
Mr. Edwards?
How do we object that? The statute in the United States Supreme Court case law says it's to be based upon the defendant's background, character, history.
This is what the case law says, and so I'm going to stick with it. In terms of mental illness, I think it would be improper for the court to tell the jury that there is a mental illness and that they have to consider that mental illness. Again, that's closing argument, and the parties may make that argument, but I don't think it belongs in the instruction. In terms of the crimes, I don't think I need to specify here that we're only talking about the crimes of first-degree murder, but I'm happy to do that if you want me to. I think it's clear to the jury that that's all we're dealing with, and I think I specified that in the final instructions, which you'll get later, but I didn't think it was needed here. I'm assuming that people agree with that, Mr. Edwards?
Yes, Your Honor.
And I'm assuming the defense agrees with that. Ms. Nelson?
May I have just a moment, Your Honor?
Yes, and I'm happy to say and the crimes of murder in the first degree, if you prefer.
We would ask that the court specify crimes of murder in the first degree.
All right, I'll do that. Okay, anything else with respect to this particular instruction, Ms. Nelson?
Yes, Your Honor. On the last paragraph, we would again maintain our request and our position that that first sentence be changed to read, the juror is convinced beyond a reasonable doubt that death is the only appropriate sentence.
Okay, same objection as before, same ruling as before.
And then
In terms of the word only, I don't think that's the law, and so I don't think it's appropriate to add the word only as in the only appropriate sentence. Go ahead.
And then finally, with respect to the last instruction, the last sentence, instead of saying further, if all of the jurors are not unanimously convinced beyond a reasonable doubt, which tripped me up a little bit when I read it and seems to suggest some sort of unanimity requirement in the other direction, we would ask the court to rephrase it, if any one juror is not convinced beyond a reasonable doubt, or perhaps if one or more jurors are not convinced beyond a reasonable doubt.
Any objection from the people?
No, Your Honor.
All right, I'll change it. I think that's fair. I'll say if one or more jurors are not unanimously convinced beyond a reasonable doubt that death is the appropriate sentence, the defendant will be sentenced to life imprisonment without the possibility of parole.
I would actually take out the word unanimously, because I
Okay.
don't think it makes sense in that context.
You're right. If one or more jurors are not convinced beyond a reasonable doubt that death is the appropriate sentence, the defendant will be sentenced to life imprisonment without the possibility of parole. Is that
Yes.
better? Okay. Great.
Yes, and then again in the last sentence, maintain our position that should read only appropriate sentence.
Same objection as before, same ruling as before with respect to the word only as it relates to the appropriate sentence, and specifically the potential sentence of death. The next instruction,
We have nothing on that third instruction.
okay? And that's the instruction, by the way, for the record that starts with the defendant may present evidence and information in phase 3, and then he goes on from there. Just so that the record is clear, the first instruction started out with members of the jury. It now becomes your duty to determine the appropriate punishment or sentence. It goes on from there. The second instruction that we talked about starts out with, in phase 3 of the sentencing hearing, there may be additional evidence presented by the prosecution and the defense. As I indicated a moment ago, the third instruction starts with, the defendant may present evidence and information in phase 3 of the sentencing hearing on his own behalf, and then he goes from there. And now we're at the fourth introductory instruction, which starts with, in phase 3 of the sentencing hearing, there is no burden of proof. Ms. Nelson.
Your Honor, we do have a suggestion on the mercy issue in instruction 2. We can go back to that now, or I can move on to instruction number 4, and we can go back to it at the end.
Let's
Whatever
go
the
back
court-
to it now.
Okay. Our proposal would be to add a sentence at the end of the sentence that currently discusses mercy that reads, each juror may decide for himself or herself the role that mercy plays in determining the appropriate sentence.
Well, I think to have it be completely accurate, it would have to read, each juror may decide for himself or herself the role, if any, mercy plays in determining the appropriate sentence, because the jury is not required to consider mercy. The jury may consider mercy if it wishes to.
In that case, we would withdraw our suggestion and request.
All right, let me ask the people, do they have any response on this in terms of the initial request or what the court suggested a moment ago?
If anything's going to be added, we agree with the court's suggestion.
Okay, all right. Well, I'm happy to add it the way I said it or something along those lines, but I think the way that it was requested, it is not consistent with the law. All right, so we move on then to the next instruction, which is number 4. And this is the one, again, that discusses in the first line that there is no burden of proof. Ms. Nelson?
Thank you, Your Honor. And just with respect to that last issue, we maintain our request that the court give it as we requested.
Right, and that request is denied. I'm happy to give it, as I said, by adding if any, because I think otherwise it conveys to the jury that they're required to exercise or to consider mercy, and they're not. They may, but they're not. So, all right, with respect to the fourth instruction.
So with respect to the fourth instruction, first we maintain the position and the objections that we've made in motions D-146 and 147, that the prosecution should bear the burden of proof and persuasion at this phase of the sentencing hearing.
Okay, I incorporate by reference my orders D-146 and D-147 rejecting that argument.
Second request, Your Honor, is with respect to the second paragraph. The second sentence currently reads, "A juror may not determine that a death sentence is appropriate unless he or she is convinced beyond a reasonable doubt that death is the appropriate sentence." And we would propose changing it to read, "A juror may not vote to impose the death penalty unless he or she is convinced beyond a reasonable doubt that death is the only appropriate sentence." So it's changing "may not determine that a death sentence is appropriate" to "vote to impose the death penalty."
And the reason why I have it the way I have it is for consistency's sake. Throughout the introductory instructions and the final instructions, I try to refer to a decision or determination as to whether the death sentence is an appropriate sentence or not, because that's what the case law talks about, and that's what I think the verdict forms will end up asking the jurors. But do the people have any say on this, Mr. Edwards?
Yes, Your Honor, we object to the defendant's proposal. We prefer what the court said is determined, especially based on the fact that it has to be based upon individual reason, moral decision-making, and not necessarily a vote. Jurors don't necessarily have to go down there and formally vote when they deliberate.
I think this language that I have in the draft is more specific and it is more accurate, and I believe that it is more consistent with the law, so I'm going to stick with it. So therefore, the request is denied. What else do you have, Ms. Nelson?
Next, we again in that second paragraph, we maintain our position that it should read death as the only appropriate sentence.
Same objection as before, same ruling as before, in terms of the word "only" before death being the appropriate sentence. What else?
And then finally, Your Honor, with respect to the definition of reasonable doubt contained in this instruction, we maintain and would request that the court omit that last paragraph based on the arguments that we made before, that reasonable doubt in this context and at this phase of the sentencing hearing really does mean a level of moral certainty, and that the description that the court has given in the previous paragraph is sufficient to convey the meaning of reasonable doubt in this context, and that it's confusing to talk about reasonable doubt being based on the evidence. If the court is not inclined to grant that request, however, we would ask, I did notice that it appears that the court has made some changes to that definition,
Right,
breaking things out into the 1, 2, and 3, and we think that it's problematic to change the definition of reasonable doubt at this point in the proceedings when the jury has been given the same consistent definition of reasonable doubt throughout. And so if the court is going to give this instruction, that we ask that it be given in precisely the same language that it was given in previous phases of the case.
Let me just say, I think, Ms. Nelson, that you tendered a definition of reasonable doubt that's similar to this one in your final instructions. So I think that's why I changed it, because you changed it. And I think the people did the same thing, at least in terms of the tender final instructions. Secondly, I changed it in anticipation that the defendant may provide a statement of allocution in phase 3, in which case I would have to include information within this definition. And I think it would make sense to the jury why at that point, and of course the lawyers can talk to the jury about that in closing argument. But given that you're asking me to change it and put it back to the way we had it in phase 2, and given that I don't know what's going to happen yet in phase 3, I don't have a problem either taking it out for now or changing it back to the way we had it in phase 2. Do the people have a preference between those two options. It might be best to just take it out so that if I end up giving this particular modified definition at the end of phase 3, there's not an inconsistency, at least between the introductory phase 3 instruction and the final phase 3 instruction. And I don't think the jury needs it at this point anyway. So, Mr. Edwards, do you have any objection to me taking it out of the introductory instructions?
Yes, Your Honor, we do. The Colorado Supreme Court has been very specific that beyond a reasonable doubt is the standard that the jurors have to use at this phase.
Right. I don't think you followed me. I'm not considering taking it out of the phase 3 instructions. I'm going to give it to them in the final instructions, either as I've given it to them in the past or modified the way I have it in this draft. My question is not whether I give it to the jury or not in phase 3. The question is, do we need to give it to the jury in the introductory instructions if we're planning on giving it in the final instructions?
And the people's position is that the court does need to include reasonable doubt in this introductory instruction.
In that case, do the people have a position as to whether it should read the same as it read in phase 2 or whether it should read as it reads right now?
We leave that to the discretion of the court.
Can't see the instructions. Just the instructions.
Your Honor, may I add?
Hold on.
Sure.
Yes, Ms. Nelson?
I just wanted to add that I'm aware that we submitted, and I think it was in our final instructions, the definition of reasonable doubt that we have been submitting throughout, and we did the same in phase 2, and it was after we had submitted phase 2 and phase 3 instructions that in reviewing the instructions we came to the conclusion that it was a potentially confusing and problematic definition for the decisions that the jurors are tasked with making at phase 2 and phase 3. So I did want to acknowledge that we proposed such an instruction and just state that our position on that had changed.
Okay, thank you. The instruction that I provided in phase 2 is as follows. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the proceedings. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. I think that if the defendant presents a statement of allocution, I do think that we will probably need to modify it. And the question is, do I keep it modified now or which I don't think is a good idea, because if the defendant does not present a statement of allocution, then the modification would be improper. And the modification, just so that the record is clear, is to include a reference to other information. So it reads as follows. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of, number one, the evidence presented in the trial and the sentencing hearing. Number two, the lack of evidence presented in the trial and the sentencing hearing. Or number three, any other information presented in the sentencing hearing that the court instructs you may be considered. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. And so I don't believe that giving it modified at this time makes sense. And so the question is, do I just delete it altogether, or do I give it the way that we gave it in phase 2, and then if there's a statement of allocution, modify it in the final instructions to include a reference to other information presented in the sentencing hearing? And Ms. Nelson, between those two options, your preference is to take it out altogether. Is that correct?
Yes, sir.
All right, I'll take it out for now. I don't think I need to give it to the jury right now. These are introductory instructions only, and the defense is specifically asking me to take it out, so I'll take it out. All right, the next one is, I think, number 5, the 5th instruction, and these are not numbered, but we're going in order, and it starts with, you are instructed that there are 2 types of aggravation that you may consider in reaching your final sentencing verdicts. And I think, Ms. Nelson, this is the one that you wanted to make a lengthy record on. Is that correct?
It is, Your Honor. However, I misspoke about instruction number 4. We still have one more thing.
Okay, go ahead.
The concern that we have with the instructions in general is that the instructions are only affirmatively telling the jury how to get, or under what circumstances they should be returning a death sentence, and how to get to a life sentence is something that's simply implied. And so we would ask that the court add something at the end of the second paragraph that contains affirmative language about how or under what circumstances the jury would reach the point of imposing a life sentence. And specifically, we would request that at the conclusion of the second paragraph, the court add the sentence, moreover, a juror need not be convinced beyond a reasonable doubt that life is the appropriate sentence in order to render a life verdict.
I know I have included language along those lines in the final instructions. I do not have here. And by the way, both of you submitted instructions that, or verdict forms that indicated otherwise. And I think both are wrong. I don't think that the jury needs to be convinced beyond a reasonable doubt to vote for a life sentence. That requirement applies to a death sentence, but the beyond a reasonable doubt certainty, as far as I can tell from the case law, does not apply to a life sentence. So if the jury is not unanimously convinced beyond a reasonable doubt that death is the appropriate sentence, they can return a life sentence if they unanimously believe that a life sentence is the appropriate sentence. Of course, if they are not unanimous on that, it's still a life sentence, but then I impose it because they're not able to reach a unanimous verdict. So either way, it ends up in a life sentence. But I don't have a problem adding language that you've requested. Do the people have an objection? I don't know that I will do exactly the language that Ms. Nelson is requesting. Let me see if I can pull up the language I have real quick.
And Your Honor,
Hold on
okay,
a second.
sorry.
What I have in the draft final instructions, which I have not yet shared with you, is the following. The degree of certainty defined by beyond a reasonable doubt does not apply to a final sentencing verdict of life imprisonment without the possibility of parole. That degree of certainty is only required for a death sentence. Any reaction to that language, Ms. Nelson?
We prefer our language because I think it's just simpler and a bit clearer. And I was also actually going to impose that perhaps that sentiment would be better placed at the end of the second instruction, after the sentence, if any one juror is not convinced beyond a reasonable doubt that death is the only appropriate sentence, the defendant will be sentenced to life imprisonment without the possibility of parole.
Which instruction are you on?
The second instruction at the very end of that instruction. Or it could go in both places.
And tell me the suggested language again.
A juror need not be convinced beyond a reasonable doubt that life is the appropriate sentence in order to render a sentencing verdict that will result in a life sentence, or simply to render a life verdict.
Do the people have a position on that?
We don't have an objection, Judge. The only objection we have is should be in one place, not in two places.
Right. I can add it. I'm happy to add it to that second instruction. A juror need not be convinced beyond a reasonable doubt to render a sentencing verdict of life imprisonment without the possibility of parole. Is that what you're asking for, Ms. Nelson?
We would ask that it read, a juror need not be convinced beyond a reasonable doubt that life is the appropriate sentence in order to render a decision that will result in a life sentence, perhaps. I think the concern is that they don't actually have to affirmatively choose life in order for a life sentence to be imposed. It's the default. So that's why I was thinking about phrasing the last part of the sentence in the way that I did. It's not a verdict for an individual juror to choose life. It's just the result of what happens when one juror is not convinced.
Yeah, I did not like that part of it in the other language, to be honest with you. Give me a second. Let me see if I have it right. It would read as follows: a juror need not be convinced beyond a reasonable doubt that life imprisonment without the possibility of parole is the appropriate sentence in order to make a decision that will result in a life sentence without the possibility of parole. Is that good?
Yes.
And the people don't have any objection, right?
No objection, Judge.
Okay, great. All right, that will be added to the end of instruction number 2.
While we're on back on instruction number 2, we had another proposal on the mercy language.
Okay?
And that would be mercy is within your personal individual discretion and judgment. Whether to grant mercy is your decision alone.
What's the people's position?
Your Honor, we object to that. I think that that's fully explained when the court says each juror may consider mercy and proceeds from there. It gives each individual juror the right to consider mercy. So to add an additional sentence is unnecessary.
How about if we added each juror within his or her personal individual discretion and judgment may consider mercy for the defendant, but mercy must be based on the evidence and information presented during the trial and the sentencing hearing. That would be the rest of it after that. So it would be included within that sentence. Ms. Nelson?
I think that's very similar to what the court already has, and we again just maintain our position that mercy alone can be a sufficient basis for a life sentence, and ask the court to amend the language accordingly.
All right, well,
that mercy is something that the jurors bring and can exercise outside of the evidence, and that they bring into the courtroom, their sense of mercy and individual personal moral judgment.
Of course they bring mercy into the courtroom, but they can't make decisions just based on mercy independent of what happened in the courtroom. That's what I keep going back to. Otherwise, again, I don't know why we took so much time in individual voir dire. If the jurors could just decide what sentence is appropriate without regard to the evidence, then why did we take so much time in individual voir dire? And why am I instructing them on aggravators and mitigators? If they can just say, I don't care about any of that, I'm just going to exercise mercy independent of that. I don't think that's how it works. So, all right, I'm happy to modify this the way I indicated, but and frankly, I don't think it adds anything anyway. I think that the point is made in the instruction. The instruction says each juror may consider mercy. That's clear that each juror has the right and the ability to do that, and it's up to them whether they do that or not. So, Ms. Nelson, you would, between the way it is right now and the way that I indicated, I would be willing to change it. What's your preference?
Repeat one more time the proposal.
Yes, each juror may, comma, within his or her personal individual discretion and judgment, comma, consider mercy for the defendant, but mercy must be based on the evidence and information presented during the trial and the sentencing hearing.
We rest on our record and
so between
we maintain our position, but between those two options, without waiving any of our positions or arguments or objections, the preference would be to leave it the way that it is.
Okay, got it. Thank you. That's how we'll proceed. All right, let's get to the instruction then on aggravating factors and non-statutory aggravating factors. I think it's instruction number 5 or the 5th in the set. Ms. Nelson.
Your Honor, we have a number of concerns about this instruction. First, we maintain our position that allowing the introduction of non-statutory aggravating evidence during this final phase of the sentencing proceeding violates the state and federal constitutions, the 8th Amendment, and Article 2, Section 20 of the Colorado Constitution, as well as due process clauses of the state and federal constitutions. And I would incorporate by reference all of the arguments that we made in Motion D-144.
All right, I incorporate by reference my order D-144, and also People versus Dunlap requires me to allow this evidence. I mean, it makes it clear that this evidence is admissible in Phase 3, and that is evidence of non-statutory aggravating circumstances. And I use the definition given by the Colorado Supreme Court in that case as to what is non-statutory aggravating circumstances. So this is not within my control as a trial court judge. I have to follow the law, and there is law on point here from the Colorado Supreme Court. So what's your next objection with respect to the instruction?
The second concern, Your Honor, is that at this point, I think the second request we would have is the court not give this in the introductory instructions. Based on the prosecution's sentencing disclosures under 32.1, it's unclear to us whether or not there will even be any evidence of non-statutory aggravating circumstances that will be introduced. It's clear that they're going to be introducing victim impact evidence, but under Colorado law, victim impact evidence is separate and distinct. It's sort of its own thing. It's not a non-statutory aggravating circumstance in Colorado. Different jurisdictions treat victim impact evidence differently. Some jurisdictions, like I know the federal system treats it as a specifically defines it as a non-statutory aggravating circumstance. In other jurisdictions, like when New Jersey had the death penalty, they discussed victim impact evidence as something that came in as rebuttal to mitigation. Colorado is never defined, and I think purposely so in the way that the statute's laid out, has never defined victim impact evidence as non-statutory aggravation. And so I don't know whether they're planning on introducing any non-statutory aggravating circumstances or non-statutory aggravating evidence. But in the event that they don't, or that they're not, then this instruction, it's not necessary and it wouldn't even apply. And so it may be confusing to give this to the jury in the introductory instructions. And so at a minimum, we would ask the court hold off and we can have another conversation about this after the evidence is presented in Phase 3.
I agree that Colorado doesn't seem to have directly decided the question as to whether victim impact evidence is non-statutory aggravating circumstances evidence or something separate from that, which is why I did not say that in the draft instructions. The draft instructions that I have do not say that victim impact evidence is included within that category of evidence. That's different than the instructions that people tendered. I just couldn't find any case law that addressed it one way or the other. Yours, Ms. Nelson, said that it is not non-statutory aggravation. The people said that it is, and I couldn't find any law on point. And so the question then is, should I take this out because these are introductory instructions and we don't know at this time whether the people are going to introduce any non-statutory aggravating circumstances evidence? What's the people's response?
Judge, just as an example, there is other evidence that has been admitted at trial that can be argued as aggravating circumstances. For example, the statutory aggravator is intentional murder of a child under 12. Having murdered a child under 12 is an aggravating circumstance. So there are aggravating circumstances already present in the crime itself that was introduced during the trial. Or another one is setting up the apartment.
Okay. Ms. Nelson?
Well, and again, if we need to have an argument about that at the final instruction conference, then we can, but if they're not presenting any additional evidence of non-statutory circumstances, then I don't think we need to be injecting this concept in the into the introductory instructions.
Mr. Orman or Ms. Pearson or Ms. Tisch-McGuire, are you intending to introduce any non-statutory aggravating circumstances evidence? And when I ask that question, I'm not referring to any victim impact evidence. And I understand the argument with respect to evidence that has already been admitted at trial, which the jury can consider. I think that's clear. And we can talk about later with respect to the final instructions, how I instruct the jury. But in terms of the introductory instructions, this implies that there is going to be non-statutory aggravating circumstances evidence introduced in phase 3. Are the people intending to do that? In other words, this doesn't tell the jury, hey, well, it doesn't, at least it implies that, and that's the part that is concerning to me, maybe confusing to them. If we're not anticipating that there's going to be anything new in phase 3 with respect to this, then why am I telling them about it now? When it seems to me it's going to be most relevant and perhaps only relevant at the end.
Your Honor, we plan on presenting victim impact evidence as we've indicated. Our position was and is that is a type of non-statutory aggravating circumstances, but I think I've answered your question.
Okay. Do you have any authority that stands for that proposition? I could not find any, and I looked at Dunlap, and I could not find any there. The court in Dunlap talked about, and again, this is 975 Pacific 2nd, 723. The court talked about non-statutory aggravating circumstances evidence, and about that type of evidence being admissible in phase 3. It also talked in a separate section about victim impact evidence, but it nowhere said whether it is or it's not, and apparently there's a split of authority in other states, although I haven't done the research or complete research in other states or done a sampling of the other jurisdictions. I'm just going off of what Ms. Nelson said, but I couldn't find anything in Colorado that specifically decided that question one way or another.
Your Honor, in the end, I don't think it really matters. I mean, if it's something that the jury can consider, whether we call it victim impact evidence that they can consider, whether we call it part of the totality of the circumstances they can consider, whether we say it fits in the category of non-statutory aggravating circumstances or factors, I don't really think matters all that much as long as the jury can consider it. So maybe that's why they didn't differentiate it. It's all something the jury can consider. I suppose it's possible to say that non-statutory aggravating circumstances is everything other than victim impact that's additional that the jury can consider. I don't really think that makes much of a difference. I've read the case. I understand exactly what Your Honor is saying, but I don't see what else it is other than a non-statutory aggravating circumstance.
And I came to the same conclusion that you did. I don't think it makes much of a difference in the end what category or what label we give it. So for that reason, I avoided either calling it non-statutory aggravating circumstance evidence or calling it not statutory aggravating circumstances evidence because I thought that was a safer route to go. I'll think about this one. I'm not convinced that we should give it, but I'm not convinced yet that we should take it out either. I have to think more about this one. Anything else, Ms. Nelson, with respect to this instruction?
Yes, Your Honor, if the court is still going to consider giving it. The other concern, we have a couple of other concerns about the instruction. One of them is that at the conclusion of the second paragraph, we have a concern that without another qualifying sentence added on to the end, it's going to suggest that the jury can consider evidence that was offered in mitigation as non-statutory aggravation if they so choose, because it says such evidence may relate to the nature of the crimes of murder in the first degree and the defendant's character, background, and history, which is very similar to the definition of mitigation. So if the court is considering giving the instruction, which again we object to, we would ask the court add, none of the evidence, you are reminded that none of the evidence offered in mitigation can be considered by you as aggravation or a reason to impose the death penalty.
Mr. Edwards, any objection to that addition?
Yes, we do, Your Honor. Such evidence offered as mitigation, that's something that the defense does. It's not something the jury finds. So it should be something about, if you found it as mitigation, it can't be used as aggravation.
Didn't we say something about this in the Phase 2 instructions? Let me check. It says the court instructs you that you may not in any fashion consider any mitigating factor as an aggravating factor. So what if we did something consistent with that and said you are reminded that you cannot consider any mitigating factor as aggravation or as a reason to impose a death sentence? Mr. Edwards?
Your Honor, our position is this, is that that instruction from Phase 2 related to before the jury had made mitigating decisions. They have now made decisions concerning mitigators. And this, well, might be better just to exclude the sentence that says such evidence may relate.
That's another option. Ms. Nelson, does that take care of the issue if I delete that sentence? Such evidence may relate to the nature of the crimes of murder in the first degree and the defendant's character, background, and history?
May I have just a moment, Your Honor?
Yes.
Yes, and again, we object to the instruction as a whole, but we would accept deleting that sentence with respect to this specific issue.
The question then is, does that create a problem because it doesn't provide the jury any more guidance than to say evidence of non-statutory aggravating circumstances is evidence that is unfavorable to the defendant, but which does not relate to a statutory aggravating factor? I mean, I think that the way, based on the statute, the way that Dunlap talked about this, non-statutory aggravating circumstances are things that are not favorable to the defendant, which relate to the defendant's character, background, and history, or the crimes, the defendant's crimes. So it's not, just anything the jury finds unfavorable. So I actually have a concern about that. So back to square one. So the question is how to phrase the sentence that Ms. Nelson is asking for.
Your Honor, perhaps the best option at this point is not to give this instruction.
Okay. The people are agreeing to that? Yes. All right. I won't give it at this time. Great. That makes it easy, and then I'll try to work third instruction, and then I included some language from the statute as well and from the people's instruction. So, Ms. Nelson, what objections do you have to this particular instruction?
Proposed instruction number 91, which states, however, your consideration must be limited to a moral inquiry into the culpability of the defendant, not an or
It'll say you may consider this evidence in determining an appropriate.
I think you may consider this evidence in reaching your final sentencing verdicts, period, and then, however, your consideration must be limited to a moral inquiry into the culpability of the defendant, not an emotional response to the evidence.
Okay, so it's the second sentence, that last sentence that you're asking to change.
Yeah.
All right, without objection, I'll change it to, however, your consideration must be limited to a moral inquiry into the culpability of the defendant, not an emotional response to the evidence. And then, do you still want the last part in there? Remember that your final sentencing verdicts must not be influenced by prejudice, bias, passion, sentiment, conjecture, public opinion, or feeling, or any other irrational or arbitrary emotional response. Rather, each of you must make a reasoned moral determination as to the appropriate sentence on each count. Those are the last two sentences of my draft instruction. Are you still asking that I keep those two?
No, Your Honor.
So you want those out then?
Yes.
And do the people have a position on that?
No objection to that. The prejudice, bias, passion statement is repeated in the next instruction anyway.
Okay, I'll take those two sentences out then without objection.
If I may just have a moment to make sure that's our position, Your Honor.
Okay?
That's our position.
Okay, give me a second. All right, anything on the last, actually not the last one, but the next instruction, Ms. Nelson, this is the one that starts with, in reaching your final sentencing verdicts, you must treat the defendant as a uniquely individual human being, which is, I think, identical to the, or pretty close to identical, not quite identical to the phase 2 instruction that I gave the jury.
We may, with respect to the changes that were made to this instruction, to include the prosecution. So wanted to make that record.
Okay, same objection as before, same ruling as before. Without waiving those objections, do you have any changes or suggestions, and would you rather not have this be given in the introductory instructions?
No, Your Honor, our request would be to omit the third sentence. Your decisions in phase 3 of the sentencing hearing may not be the result of mere prejudice, bias, passion, sentiment, conjecture, public opinion, or feeling, or any other irrational or arbitrary emotional response. We think that the instruction communicates what it needs to with the first and second sentences, and it's a concern for us because the jury can, moral judgment and emotion are not necessarily mutually exclusive, and the jury is allowed to base its sentencing decision on emotions in favor of Mr. Holmes, if any. So we would ask the court to just omit the third sentence.
Any objection to that, Mr. Edwards?
Yes, Judge, the reason I didn't object to the last one was because the language was contained in this instruction. We believe that this instruction is important because it's basically a cautionary instruction to the jury that they shouldn't use any prejudice or bias, and that they can't consider mere prejudice, bias, etc. And that's important because it's a continuing process. As the evidence is coming in, they need to be reminded that they can't do that.
And the second sentence in that instruction already discusses prejudice or bias and public opinion and community sentiment, which is part of the reason we felt it was redundant.
How about if I change it to your decisions in phase 3 of the sentencing hearing may not be the result of an irrational or arbitrary emotional response? It seems like the other parts of that are covered earlier in that instruction in terms of the bias and prejudice. What's the people's position with respect to that, Mr. Edwards?
We have no objection to that, Judge.
Ms. Nelson?
Our concern is that that implies that emotion is necessarily irrational or arbitrary, and that it can't play a role in their decision to impose a life sentence, which we think is not an accurate statement of the law.
That's not how I read it. I read it as the decision cannot be the result of an irrational emotional response or an arbitrary emotional response. That implies to me that emotion can play a part in this. It just can't be arbitrary or irrational. So I read it as the opposite, actually. And I think the case law is pretty clear, too, about saying that the decision cannot be the result of mere prejudice, bias, passion, sentiment, conjecture, public opinion or feeling, or any other irrational or arbitrary emotional response. And it's saying mere, so it's saying, it can't just be the result of prejudice or the result of bias or the result of passion or the result of sentiment or the result of conjecture or the result of public opinion or feeling or just the result of any other irrational or arbitrary emotional response. If you prefer, Ms. Nelson, I'll just leave irrational or arbitrary emotional response, but frankly, I don't have a problem with that sentence. But I'll leave it to you without waiving your objection. What's your preference between those two? Yes.
Your Honor, without waiving our objections to the sentence in its entirety, we would prefer that the court amend it as proposed. But we would also, I think there was an instruction the court gave, if I'm not mistaken, at some point in phase 2 that said something along the lines of, you may consider sympathy for the defendant, but such sympathy cannot be something, and then it was something along the lines of what you have here, and we would ask that the court add something affirmative to this instruction affirmatively stating that you can consider sympathy or mercy for the defendant. Mistaken about that, Your Honor. That was just my recollection.
I don't show the word sympathy at all in the jury instructions at the end of phase 2. I think the word sympathy appears in the standard model instructions for trial, and I think at your request we took it out before phase 1 because it generally tells the jury that it cannot make decisions based on sympathy. So that may be what you're remembering. But with respect to this particular sentence, I will amend it as Ms. Nelson has indicated, so it will read, your decisions in phase 3 of the sentencing hearing may not be the result of any irrational or arbitrary emotional response.
May I have just a moment, Your Honor?
Yes.
We would request the first sentence read, in reaching your final sentencing verdicts, you must treat the defendant as a uniquely human being and may consider sympathy and mercy for Mr. Holmes. I think that the sympathy omission from the second instructions was that you may not consider sympathy, and the court took that out at our request because it's our position that you can consider both sympathy and mercy for him, and that's particularly appropriate and important to point out to the jurors in phase 3. So that would be our request.
We took that out, I think, before the phase 1 instructions, final instructions, but in any event, they were not in the phase 2 final instructions. Do the people have a position on this request?
We object to it in that instruction. If you want to add the word sympathy, I would hate to say this, but I would go back to instruction 2 that we've been having lots of problem with. In the middle of the second full paragraph.
Each juror may consider mercy and sympathy for the defendant, but mercy, then he would read, but mercy and sympathy must be based on the evidence and information presented during the trial and the sentencing hearing. That sentence?
Right.
Ms. Nelson? Yes.
Our position is as I stated previously, but without waiving anything, we don't object to including and adding the word sympathy in instruction number 2.
Okay, I'll change instruction number 2 as I indicated a moment ago. I think it is more appropriate to put it there, otherwise it's repetitive. So that sentence in instruction number 2 will read as follows. Each juror may consider mercy and sympathy for the defendant, but mercy and sympathy must be based on the evidence and information presented during the trial and the sentencing hearing. Anything else on the penultimate instruction, Ms. Nelson?
No, Your Honor.
Anything on the last instruction?
Your Honor, we would ask that the court omit the words penalty or, and just state any decision regarding the appropriate sentence on each count.
Okay. Anything else?
And then we would ask that the court omit the last sentence as redundant.
I think I took that from yours.
No. If you did, then we change our position.
Yeah, it's in yours. Then and only then may you begin to deliberate. It's also in the people's standard instructions. So do you want to leave it in? You still want to take it out? Do the people have any position on that? And by the way, you used penalty in that second sentence in your standard instruction. I think the people did as well, and I added or sentence, but I don't see a problem taking out penalty or. The people don't have any objection to that, right?
No, Your Honor.
All right, what about the last sentence?
I think the last sentence is important because it says when they can begin to deliberate.
I agree. So over objection, I will leave it in. All right, is there anything else with respect to the instructions, the introductory instructions that we need to talk about at this time from the people? Any other tender instructions, introductory instructions?
No, Your Honor.
Any other requests or objections?
No, Your Honor.
Same questions for you, Ms. Nelson. Any other instructions, introductory instructions that you want to tender?
No, Your Honor.
And any other objections or comments with respect to the introductory instructions?
No.
Okay, great, thank you. All right, let me talk to you briefly about the victim impact evidence then, if I may. All right, first of all, as a general matter, I understand that this is very difficult for folks. I get that. But I'm going to rely on the lawyers to make sure that they control the testimony. I know that's not an easy thing, but the lawyers are going to have to do that. And so the lawyers are going to have to make some calls in terms of who and I'm referring to the prosecutors, in terms of who they call to the witness stand, because there's no way around that. People have to follow my orders. People have to comply with my orders. There's no ifs or buts. While it's understandable that people may get emotional, they have to be under control when they testify. And if that's something that somebody can't do, then it's up to the people to figure that out ahead of time. And I've made some rulings with respect to the type of evidence that I'm allowing. So that's the first sort of global comment. The second is the defense, in response to P83, made some specific objections, and I have, for the most part, ruled on those objections, although I'm going to go through some things right now. But if there are any other objections, the defense has to make them and let me know that they're objecting. So, for example, I have not ruled on anything that's not based on some type of relevance or 403 objection. So if there is an objection beyond that, then you have to make it, and I'll rule at that time. In terms of 403 objections, although you made some specific objections with respect to that, it's hard to make those rulings in a vacuum ahead of trial. I did the best I could in the pretrial motion, but the reality is that I am in a better position to assess 403 objections when we're in the middle of the evidence being presented. So in terms of, for example, cumulative objections, you have to make those at the time the evidence is presented. It may be that given other evidence that has been presented, a 403 objection would be sustained, whereas in a vacuum before the hearing, it was not. So again, if you as defense attorneys believe that we're in a situation where the evidence is overwhelming and the jury's being affected, then you're going to have to let me know at that point. I'm not saying that I will agree with you or disagree with you, but I will rule on whatever objections you make. And I'll leave it to you to decide whether you want to object or not. In terms of some of the disclosures that I have read, it seems like, Ms. Tish McGuire, you have disclosed with respect to almost all, if not all of the witnesses, that they intend to talk about the last contact that they had with their loved one. And it includes the last, in some cases, the last phone call, the last text message, the last physical contact. You got to pick one. So I'll let you figure out which one, but I don't mind if people say this was the last physical contact I had with my loved one. And then you can ask if after that there were emails or phone calls without getting into the details of those emails or phone calls. But pick one. You can't go into the last text, the last voicemail, the last email, and the last physical contact. So you need to pick one of those. And that type of testimony, as you know, can get dramatic and emotional. So it needs to be brief. Same thing with respect to how the witnesses found out about their relative being at the theater and finding out that they had died, that they did not make it. That testimony can get emotional and dramatic. So again, that should be brief. And the last thing is with respect to steps to find out what happened to their loved ones, what they did as they were trying to find out what happened to their loved ones. That kind of testimony can be emotional, and so it should be brief. There are a couple of people who apparently intend to testify that they have attended the trial throughout to honor their relatives. I'm not going to allow that. That may well be, but I don't know that qualifies as victim impact evidence. So a lot of people have attended the trial, and I don't think that should be admitted. Even if it qualifies as victim impact evidence, under Rule 403, I find that the probative value is substantially outweighed by the danger of unfair prejudice and by the unnecessary presentation of cumulative evidence, given what else the people have disclosed. There were some disclosures that refer to the events that trigger memories of the charged crimes. And I don't know what that means. It was separate from events that trigger memories of the loved ones. And it seems to me they're sort of one and the same. And so to the extent that it's all related to this, to things that remind people of their loved ones and how they died in the theater shooting, that's one thing. But if you mean something different, then you should approach the bench and we can talk about that, because I don't know what that would mean. I don't know what events there would be that trigger memories of the charged crimes, but not of the loved one. So I know that I've made a ruling with respect to media coverage and any references to media coverage. So that is out, and that I've explained why. To the extent that you intend to call more than one witness with respect to any victim, it can't be just repetitive. And of course, the defense will be free to make objections under Rule 403. I don't think there's an objection to the people calling more than one person. I think the maximum the people intend to call with a few witnesses or with a few victims is 2 witnesses, and it's only with respect to a few victims, 3, I think. So if there's an objection, the defense can make the objection, and I'll rule on the objection. But to the extent that I allow it, it should not be cumulative. In other words, it should not just be repeating the same thing. And then the last thing, global thing, and then I'll go through some more specific things. There are some disclosures that refer to the impact on friends. And the statute is not clear in Colorado that it includes friends. And I know that in Order P83B, I addressed this a little bit on pages 7 and 8. But, the statute refers to family. And I know that the defense had an argument that it should be immediate family only, and I rejected that argument. I don't think that there's any limit on a friend being able to testify, but that friend would have to testify about the impact on the family members and the impact, and also the individual unique characteristics of the victim. I don't think that at least I'm not aware of where the statute says that any impact on friends and coworkers and acquaintances or other people is also victim impact evidence that is admissible. Ms. Tish McGuire, am I missing something?
Your Honor, I think that the court has an excellent point. I mean, the statute says that it's any matters relating to the personal characteristics of the victim and the impact of the crimes on the victim's family. And you're right that there's no friend there. And then it says any such evidence, including but not limited to the testimony of members of the victim's immediate family. So I think the court's right that if we wanted to call a friend, perhaps the statute would allow that. But the people are happy to comply with the court's order and not elicit testimony regarding victims' friends.
And I don't know what the legislature meant by including but not limited to immediate family, because there it used immediate family, whereas in the sentence before it used family. So it's possible that what the legislature meant was immediate family, but also other family members, or it's possible that the legislature meant friends and co-workers, anybody else, but without any direct authority on this, I'm going to err on the side of caution. And to the extent that you want to call friends, they can testify, but I'm not allowing any evidence related to the impact of the deaths and the crimes on non-family members. Does that make sense?
Yes, Your Honor.
And again, friends can come in and say, well, I'm very familiar with this family, and here's the impact on the family. Friends and co-workers can also say, I was very close to the victim, and let me tell you about the individual characteristics of this victim. I think they can testify about that. I'm just not allowing evidence of the impact of the crimes on non-family members, okay?
Can I just clarify one thing, Your Honor?
Yes.
We do intend to elicit some testimony regarding the number of friends that victims had, which we think goes to their personal characteristics, that they were gregarious, outgoing, caring, loving individuals, and not the impact it had on those friends, but just that they had that many friends in general.
I don't see a problem with that. I agree that potentially or arguably goes to the individual characteristics of a victim. Again, if there's an objection, I'll rule on the objection, but that does not run afoul of my ruling. Let me see if there's anything else that's general or global. The last thing I'll say is I'm going to be watching the jury closely, and as this goes on, I'm going to be assessing how much I'm going to allow or not. You might remember that in McVeigh, at some point the defense objected because there was so much focus on just how the witnesses found out about the victims perishing in the bombing, the Oklahoma bombing, and also about the last time the witnesses saw the victims, and the last kiss and the last conversation and that kind of thing. And the court at some point, with the people's agreement, frankly, the people agreed to pull back on some of that evidence because the court noticed that it was particularly emotional and dramatic testimony. And so the court allowed it. I'm allowing it. I think it is admissible, but as we go on, I'm going to be assessing things to make sure that the jury is not overwhelmed with emotion, and to make sure that the jury's ability to make a reasoned moral judgment or determination is not interfered with. So in terms of the more specific things, with respect to Chantel Blanc, Chantel, in the disclosure it says that she intends to testify, I think it's Chantel Blanc, about how the victim's grandparents have cancer and are battling cancer without their grandson's help. I think that's a little attenuated, and again, given what else is in the disclosures, I'm going to keep that out. And that's pursuant to Rule 403, and based on my analysis of the probative value of the evidence being substantially outweighed by the danger for unfair prejudice, as well as the unnecessary presentation of cumulative evidence. With respect to Mary Teresa Hoover. Apparently, she's intending to testify about the impact of A.J. Boyd's death on his girlfriend and or fiance, and I don't think she qualifies as a family member under the statute. So that's pursuant to my ruling, that would be out.
Your Honor, may I make records regarding these objections? You want me to wait until you're done with all of the specifics?
Why don't you wait until the end?
Okay, thank you.
And, you know, she's been referred to at times, I think, as a girlfriend and at times as a fiance. And so I'm not exactly sure, but I don't, at least based on my understanding of the statute, I don't know that that is included. And again, I don't mind if she wants to testify and talk about him. She's entitled to do that. I just don't think that, at least under the statute, the impact that his death had on her is admissible. And if you have authority that you want me to look at, I'm happy to look at it. The next one is with respect to Jesse Childress's best friend, and again, that's pursuant to the ruling I made a moment ago. That, I think, is on Lisa Childress's disclosure. With respect to Sandy Phillips, I talked already about the attending the trial to honor the memory of her daughter. Again, I don't doubt that, but I don't know that that qualifies as victim impact evidence. And again, under Rule 403, I'm keeping it out for the reasons I stated before. She also, in her disclosure, the people also indicated that she may testify about how she has begun working to change gun laws across the country. That may well be, but again, under Rule 403, the probative value of that evidence is substantially outweighed by the danger of unfair prejudice, so I'm keeping that out as well. Again, given how much victim impact evidence that people have available, I also find that that would constitute the unnecessary presentation of cumulative evidence. And then there is also mention here of the impact on a good friend of Jessica Gowie, and I've talked about the impact on friends. With respect to Kathleen Larimer, again, there's the inclusion about attending the entire trial to support the memory of her son. I've talked about that, so that's out based on my ruling. And the impact on John Larimer's friends. So that, again, is out pursuant to my rulings. And let me just say that the closest call on the issue of friends is with respect to Mr. Boyd's fiance. So that's obviously a close call, but the other ones, I just don't think under the statute the way that it could reasonably be interpreted that it comes in. Next I have Nora Wilwert, W-I-L-W-E-R-T. And I may have misunderstood this part of the disclosure, but part of the disclosure says that she intends to testify about her favorite memories of her three other siblings. So I'm not sure how that relates to the victim. If it's related to the victim's interaction with those siblings, then obviously it's fine. Is that what you meant?
Yes. Sorry, Your Honor.
Okay, then that's fine. Then, again, testimony related to attending the trial. I've talked about that. The impact on John Larimer's friends. I've talked about that. The next one I have is a disclosure related to Ms. Jerry Jackson that includes impact on Matt McQuinn's girlfriend and roommate. Same ruling with respect to those. With respect to Amanda Medic, it includes testimony regarding that her dad's biggest fear in life was that something would happen to his children and that it came true. And I wasn't sure how that went to impact on dad. The impact is, as a result of the death, how has he been affected? I just didn't know how that connected to whatever fear he may have had ahead of time. So, and Ms. Tish McGuire, I'll give you a chance to address that at the end, but short of an explanation, that would be out. Same thing with Gregory Medek's proposed testimony, which would include the same type of testimony, apparently. Next, I have the proposed testimony of Tom Sullivan. In the disclosure, it says testimony regarding planning for all of their relatives to come to a funeral and making arrangements for all of the out-of-town family. I just didn't see that had much probative value. Again, given what else the people have disclosed that they may introduce into evidence, I'm keeping that out under Rule 403. It just seems to me that this is the type of thing that people do whenever someone dies. And I didn't see what the probative value was with respect to that particular point. The media is mentioned here. I ruled on that already. Robert Sullivan. In the disclosure for Robert Sullivan, it says that the murder of a 6-year-old girl is an incomprehensible tragedy. My concern about that is I think it gets really close to the type of evidence that's inadmissible in terms of none of the victim impact witnesses are allowed to opine or testify about the crime or the type of punishment or the defendant's character. So when I read that someone intends to testify that this was an incomprehensible tragedy, that the murder of a 6-year-old is an incomprehensible tragedy, that gets too close for my comfort level. So I think he can express the impact of his granddaughter's death on his life with the rest of the disclosure. I just didn't think that was appropriate, so I'm keeping that out. The media coverage is mentioned there, so I've ruled on that. Testimony regarding how sad it was that because Ashley Mosher was injured so badly, Veronica Mosher Sullivan's funeral had to be delayed, and because of the delay, family and friends who initially came out to support the family could not also afford to come back to attend the funeral. That seems to me more related to the impact of the injuries on Ashley Mosher as opposed to the death of Veronica Mosher Sullivan. So I'm keeping that out under Rule 403. Next, in terms of Ashley Mosher, I have something similar, testimony related to how difficult it was to have to delay the funeral of her daughter, Veronica Mosher Sullivan, so that she could take part in the funeral. Same ruling with respect to that. With respect to Karen Teves, I have, again, testimony related to attending the trial to honor her son's memory. Same ruling that I made before with respect to that. And then it says testimony regarding how she constantly wondered if her son was specifically targeted by the defendant in the theater. I'm excluding that. I think that calls for speculation, and I think, again, that gets too close for my comfort level to having an opinion about the defendant's character, to having an opinion about the crimes in question, so that's out under Rule 403. The next one I have is Ms. Weigel, W-Y-G-A-L, and in the disclosure it includes an entry for testimony related to how difficult it has been to grieve for her daughter when her daughter was part of a mass shooting that has been so publicized and so intensely public. She feels like this has inhibited her ability to grieve. Again, I don't question that may well be the case, but pursuant to my ruling on publicity and the media, that's out as well. Next, I have the disclosure with respect to Robert Wingo, and this is the last one. And this is it says testimony regarding his marriage to Rebecca Wingo. And apparently Robert Wingo was Rebecca Wingo's former husband and was her former husband at the time of the shooting. I just didn't understand what that meant. I mean, if he is going to come in and testify about individual characteristics of Rebecca Wingo, then obviously that's admissible. If he's going to come in and testify about their marriage in other terms, then that may not be admissible. So I highlighted it to talk to you, Ms. Stitch McGuire, about it. Obviously, it has to be connected to the impact of the death, of Rebecca Wingo's death and the crimes on him. And if he wants to talk about the marriage they had, to describe the kind of person she was and how she acted and the qualities that she had and the traits that she had, I think that's fair. But I just didn't think if that included something else related to their marriage, so that's why I highlighted it. All right, are there any of those that you want to address, Ms. Tish McGuire?
Yes, Your Honor, and I also wanted to address globally as well some of your global concerns. I don't know if you want me to do that first or afterwards.
Either way.
Maybe I be permitted to sit here, Your Honor?
Yes.
Okay, I appreciate that. First of all, Your Honor, I know that the court is trying to strike a very careful balance to make sure that we protect this case. And the people understand that there's not a lot of Supreme Court case law that gives the court a lot of guidance.
There's not, and it's a particularly difficult job because on the one hand, I have to protect the defendant's right to fairness. I have to. I'm required to do it, and as a judge, I've taken an oath to do that. So that's not discretionary, and there is plenty of case law talking about how careful you have to be with victim impact evidence. On the other, I'm also aware of case law that says, hey, judge, the people are entitled to present victim impact evidence to show the harm caused by the crimes, and furthermore, the people are entitled to show the magnitude of the crime. And this is not a case like any other case that any of us have had, and it would be improper for me to treat it like that. And that's the difficulty. Where do you draw the line? And that's what I'm trying to balance here. On the one hand, giving you an opportunity to paint a full picture of the magnitude of these crimes and how many victims there are and what all is involved, how many people were affected, all of that. That's part of it. On the other, I have to make sure that this does not overpower the jury to the point where they make an emotional decision and not a decision based on reason, moral judgment, which is what's required. So I'm balancing those two, and I'm going to be watching the jury throughout the proceedings to do my best to make sure that both of those interests are given effect.
Thank you, Your Honor, and the people appreciate that. Citing from Payne v. Tennessee, as the court well knows, the federal constitution bars victim evidence only if it's so unduly prejudicial as to render the trial fundamentally unfair. And Payne also states the state has a legitimate interest in counteracting the mitigating evidence which the defendant is entitled to put in by reminding the sentencer that just as the murderer should be considered as an individual, so too should the victim as an individual whose death represents a unique loss to society in a particular family. And so the people will follow the court's rulings, but just because we have an interest in victim impact evidence and there being good case law on that, the defendant was able to present evidence of his last phone calls with his parents, his last emails with his parents, his last contacts with his parents, and he was able to present evidence that his parents were in court every single day, except with the exception of whatever days Arlene Holmes said she wasn't present. And so in order for us to adequately counteract that mitigation that was presented to the jury, we feel like it's appropriate that the victims be able to talk about those things as well. So we would just make that record. Additionally, Your Honor, as to the court's question about media, we just wanted to clarify, we have some victims who learned about their children's death from the news. They turned on the television and that's how they learned that their children were murdered. Is that permissible if we don't talk about the other impact of media?
Yes, I haven't excluded that. What I'm excluding is any testimony about the impact of the publicity the case has received and the media attention these criminal proceedings have received. That's what I'm excluding. because again, I think it's somewhat attenuated in terms of the impact. That's not to minimize what they have gone through at all, but there is some, it's attenuated in terms of the connection between the impact on the victims, which is very real, and the defendant's actions. And I know that there's not a requirement for a causal link. I get that. But I also could not find any case law that said this is allowable. I also could not find any case law that said attending a trial to honor one's deceased family members is victim impact evidence. So some of what I'm keeping out is because there's no case law that I see out there, and you have plenty, and I mean plenty, of victim impact evidence to present. So when you talk about counteracting the mitigation evidence that was presented, I am aware of that. I am aware of that language, which is why I'm making some modifications to my previous rulings at this point. And I think it is appropriate for me to do that. So I am keeping that in mind. And regardless of whether that language refers to the defendant's opportunity to present mitigation evidence or whether it refers to the actual mitigation evidence that was presented, and I think it's the former, not the latter, but either way, I feel comfortable that these decisions are appropriate and strike the right balance. But you should know that I'm doing that with all of that in mind, that I have taken all of that into account. If you had one victim and you had one or two witnesses, I might have come out differently. But you have 12 victims here, and you're intending to call up to 15 or 16 witnesses. And each of them has, based on the disclosures at least, quite a few things that they intend to talk about. So all of that has been taken into account, and this is my best attempt to try to strike the right balance here.
Thank you, Your Honor. And the people appreciate that, and obviously the court understands this as well, but the people are in a difficult position as well because there's one person who's responsible for 12 murders, and that's the defendant, and the people feel like we still have to adequately present victim impact evidence as to each person who was murdered and treat it as they were individual murder cases to respect the victim impact to those families.
I understand, but, it's not the same rules that apply to the two, and you know that. This isn't just coming from me. The rules that apply to mitigation are very different than the rules that apply to victim impact evidence. In terms of mitigation, the case law tells me to be as flexible as I can, to give the defendant every opportunity to present all the mitigation that he wants to present. In terms of victim impact evidence, the case law doesn't say, Judge, you should bend over backwards to allow as much victim impact evidence as you possibly can. To the contrary, it says, trial court judge, be careful. Be careful because this evidence has a strong potential to evoke emotions, strong emotions. So you best be careful. And that's what I'm trying to do. So this isn't just because I feel like doing it. This is because I have to follow the law and I have to make sure there's fairness here for both sides. So in terms of the emails and phone calls and contacts and things like that, you're right. The defense had every opportunity to present a lot of those. But again, the rules are not the same. And by the way, there were some things that I excluded that I felt needed to be excluded even from the defense's mitigation point of view. So I did not allow everything, but I think giving you an opportunity to have people talk about the last contact they had, and they can pick whichever one they want. Whatever most significant contact they want to talk about, I will give them that opportunity. But they have to choose one. It can't be, well, here's the last email, and here's the last tweet, and here's the last, text, and here's the last physical contact. And again, this is my attempt to be careful, especially when it comes to that evidence of last contact, because I know that tends to be very emotional, dramatic testimony. And that's what the trial court judge eventually concluded in McVeigh, and the prosecution on their own said, Judge, we will stop. And so, anyway, go ahead.
Thank you, Your Honor. And Your Honor, the people concur with the court about the ruling about the friends. I would ask the court to reconsider both regarding Teresa Hoover's testimony about Los Samoa Cross. Los Samoa Cross was AJ's fiance. They secretly got engaged a week before the movie theater. And so I would cite the court to 24 4.1302 and the definition of victim's immediate family, which means the spouse, any child by birth or adoption, any stepchild, the parent, the step-parent, a sibling, a legal guardian, a significant other, or a lawful representative of the victim. And so the people would argue that Los Samoa Cross was most certainly a significant other of A.J. Boyk. And for the same reason, the people would request that the court allow testimony from Jerry Jackson about Samantha Yowler, because she was a significant other to Matt McQuinn. They were together for over 3 years. They moved from Ohio to Colorado to be together. And the only reason they weren't engaged was because Samantha was not ready to be engaged, but Matt had proposed to her on several occasions. So we would concur about all the other friends, but given the definition of victim's immediate family in that statute, we'd request those two exceptions.
Does the defense have a position on that?
Judge, we do object to that, and I don't know if the court addressed on page 23, Amanda Lindgren is also a girlfriend of Alex Teebs. So I don't know if the court wants to address her at this point also.
And to clarify, Your Honor, the people would also seek an exception for Amanda Teebs as well. They were together for 2 years and went to graduate school together and had hoped to get married as well.
All right, and so the defense would object to that one too. And you're reading from the definition of immediate family member?
Correct, not just victims, but victims' immediate family. And I can give the court the subsection.
That's okay, hold on.
It's subsection 6 of that statute.
All right, I'm looking at the defense's response to P83, and in a footnote 8 on page 8, it says, Colorado Revised Statute, Section 18.1.3.1201, subsection 1B's reference to Section 24-4.1-302, subsection 6, which defines immediate family in the Victims' Rights Act. The defense believes it is appropriate to define family the same way the Act defines it, as including the spouse, any child by birth or adoption, any stepchild, the parent, the step-parent, a sibling, a legal guardian, significant other, or a lawful representative of the victim. And so that definition refers specifically to a significant other, and it distinguishes it from a spouse. So, Ms. Teach McGuire, I'm going to reverse myself on that, only if you can establish the appropriate foundation, obviously. It has to be a significant other, but if it is a significant other, I think that is family, and so I'll allow that.
Thank you, Your
So
Honor.
establish the foundation first, okay?
We'll do that.
What else?
As to, and again, we'll respect the court's ruling, but just to make a record, as to Chantal Blanc, the reason that it's actually impact that the grandparents are battling cancer and that Jonathan's not alive is because Kay and Tom Blanc actually raised Jonathan, Kay, and Tom Blanc actually helped raise Jonathan Blanc. And I think it is an impact when you raise a child that you hope one day that they can care for you when you get old and sick. And they don't have other family resources, and the fact that Jonathan is not around to help them is a huge impact to the grandparents.
So they don't have any other grandchildren, is that what
They
you said?
don't have any other grandchildren, Your Honor. So the only person who has also been able to help them is Jonathan Blanc's widow, Chantal Blanc.
And when were they diagnosed with cancer, before the shooting or after the shooting?
After the shooting.
Does the defense have a position on that?
Your Honor, we object.
I'll think about that one.
Okay, thank you, Your Honor.
What else?
I would say for Amanda Medic's testifying, the court had a question about that Greg Medic's greatest fear in life was that his children would die. And you wanted to know how that was impact to Mr. Medic. And,
What page are you on?
oh, I apologize, Your
That's
Honor.
okay. Okay, thank you.
The people would argue that Mr. Medic lives his life in a very different way now as a result of Michaela's murder, because he thinks that every single one of his greatest fears will come true, given that his worst fear in life did come true, that his daughter was murdered.
Okay. The defense objects.
Yes, sir.
All right. I'll think about that one too. What else?
As to Tom Sullivan testifying, I also just wanted to clarify one more thing. Mr. Sullivan actually asked the media to help him find his son because he was unable to locate his son in any hospital. And so I also wanted to know if that was differentiated from the other media ruling or if that would fall within the media ruling.
Yeah, no, that's different. Again, my ruling is just with respect to whatever effects the publicity, the event, and the case have received, not anything else. So that does not come within the scope of my ruling.
And then I would just ask the court to reconsider Ashley Mosier testifying about the fact that her daughter was murdered on July 20th of 2012, and she was not able to have a funeral for her daughter until October of 2012 because of the actions of the defendant. But for the defendant's actions, she would have been able to have a funeral right away, and the family could have started the grieving process earlier, but that was delayed because of the defendant's actions.
The jury gets it. I mean, the jury doesn't need the connection. If the jury has heard her testimony about her injuries, if the jury hears that the funeral took place in October, the jury will make the connection. They're not stupid. They're very smart people. So I just don't, to me, that goes more to the impact that her own injuries had on this, not, so in other words, this is the impact the crimes had on her more than anything else. And so I'm still keeping that one out.
And then the court asked the people to clarify regarding testimony of Robert Wingo about the marriage to Rebecca Wingo.
Yes.
And it was as the court suggested. It was the characteristics that helped is why he fell in love with Rebecca, the great reason she was a mother, how they co-parented even after they were divorced. And those were the things that the people are going to elicit, not and other things about their marriage.
Okay, great. That makes sense. Okay. Anything else?
Not regarding this, Your Honor. We do have some other matters to bring up to the court after these.
Okay, I will think about those two things that I mentioned. Is there anything from the defense with respect to the victim impact evidence and specifically the people's supplemental disclosure? I will think about the two outstanding things that I mentioned. I need to give that more thought. And by the way, going back to that family issue, the more I think about it, a significant other is family. And so it's consistent with common sense as well. So not only because it is specifically included in the definition of immediate family that is referenced in the statute, but also because just as a matter of common sense, a significant other is family, is part of your family. So, all right, Ms. Brady, anything else with respect to victim impact evidence and specifically the people's supplemental disclosure, which I think I relabeled P83D as in Denver?
Your Honor, the court noted that the people intend to have more than one witness testify with regard to a couple of the deceased victims, and we would object to that. We would ask for an offer of proof as to what would be different or unique prior to them getting on the stand, rather than having to object in the middle of the testimony at the risk that the testimony would already have been presented to the jury. In addition, Your Honor, we would note that there are a number of offers of proof with regard to the victim impact evidence which tend to indicate that they rely upon hearsay. And so given that the court has ruled that the rules of evidence do apply in a sentencing proceeding, we do make a global objection to any evidence based on hearsay. I think that a lot of times includes what people told them about what happened at the scene or what happened with their loved one. I mean, there's a whole host of things that seem to me to rely upon hearsay throughout this motion, so we would put the court on notice of that and ask the court to advise the people that hearsay is not allowed with regard to this testimony. Your Honor, we also received a disc of the final videos that the people intend to introduce with regard to victim impact evidence, as well as the specific photos, and I do have specific objections to make on those. And Your Honor, we would incorporate the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as Colorado Constitution, the similar provisions in the Colorado Constitution. And we'd also just remind the court that we do preserve all the objections and legal arguments that we made with regard to victim impact evidence in D-166, 167, 168, 188, 188A, and 242.
All right, in terms of the hearsay global objection, if you think, Ms. Higgs, that there is some evidence that's being presented and that it is objectionable pursuant to the hearsay rules, make your objection and I'll rule on the objection at that time, okay? In terms of the request for an offer of proof, to the extent that the people intend to call more than one person, I think that probably the best way to proceed would be to wait until the people call the first witness, and then I can be in a position at that time to hear what else the people are intending to have the second individual talk about. Does that make sense? And is that okay with the people?
Well, Your Honor, we would object to having to give an offer of proof before any witness is testifying in this proceeding. The people have already given the defense an incredible amount of detail regarding our witness's testimony, which was above and beyond what the court asked the people to do. we clearly understand the court's ruling that we're not allowed to present cumulative testimony. But it's hard, I agree with the court, it's hard for me to know if a mother decides to not talk about a story that then the sister also knows maybe the sister wants to talk about that story. And it may be hard to know until after that testimony. And if the court requires us to do so, we will do so. But we would prefer to not have to make an offer of proof, but we'll stand by the court's admonishment that we should not present cumulative testimony from those additional family members.
And Your Honor, I would just note briefly that in the prosecution's proffer in P083A, when they have cited additional witnesses for specific victims, much of it is just repeated from the witness before, so it's hard for us to know what is different about those witnesses and to know what we can object to in advance.
Yeah, that's the same concern I had. In the disclosures that you made, Ms. McGuire, there is a lot of repetition. Now, in all fairness, you made those before my ruling, so I understand that. So I'm not asking that you tell me word for word what everyone's going to say, but I'm still going to require you to tell me in general, give me categories, and give me the type of disclosures that you made before when you intend to call a second person, just so that we know where we're going, where you're going with it, and then if there are any objections, then I can take any objections at that time. So again, I'm not asking for specifics. I'm just asking for categories, general categories about what you intend the second person will testify about. In terms of the final videos and photographs, are those related to the CD that I reviewed before, or is this something else, something different?
Your Honor, I believe the court has, in some totality, reviewed all of those photos at some point in time. The defense asked me if, as a favor to them, I would put just the victim impact photographs and the videos on one disc, which I did do, and I'm happy to provide that same disc to the court if the court would like. It was just kind of handy for them to just have all the victim impact photos together instead of as, they were discovered throughout the trial, or throughout the 3 years.
Well, my recollection is that there was an objection that the defense made, and I looked at some videos and some photographs as a result of that. And then I sustained the objection in part, and I issued a ruling and ordered the people to modify the videos and the photographs. So are these different videos and different photographs than those that I've already ruled on?
Your Honor, I can tell the court what it is I'm specifically referring to.
Okay.
What is on this disc are the 4 videos that have been previously litigated that the court has reviewed and that the people have since modified as a result of the court's rulings. I have one additional objection to those videos. And then we have been given a number of photos from the prosecution, but it has not been identified to us specifically which photos they intend to introduce during this part of the trial. So those photos are also all on here, and there are at least, I believe, 75 photos, and I don't have objections to all of them, but I do have additional objections to some of them in particular. And now that we know which ones for which people, we're able to analyze the admissibility of these further, and so I would like to make those objections.
Are you intending to introduce all of those pictures?
I am, Your Honor.
Okay. Well, I guess I'm trying to figure out why we're having this discussion now on the eve of the evidence being introduced. I mean, I'm trying to make sense of it, that's all. I remember that the defense made an objection to some videos and some photographs, and so then I ruled on those. And I think in my order, I specifically said that once the changes were made to the videos and the photographs, that if the defense had any additional objections, that they had to make a timely objection. I would not call this timely. So if it's related to those videos that were redacted already and those photographs that were modified pursuant to my order, then I'm not sure why the defense waited until now. And to the extent that this is related to other photographs, then I'm not sure why this wasn't brought up when I ruled on the initial video and photographs.
Your Honor, the only photographs that I recall the court ruling on are the photographs that are contained. Like one of the videos is a photo montage of like Mr. Cowden or the photo montage of A.J. Boyk. These photographs are separate from those that are contained within those videos.
And you had not seen those before?
We have been given a number of photos by the prosecution, but they have not been identified to us as proffered within their 32.1 disclosures. They have previously said we're going to introduce some photos, but they have not given us any specific 32.1 disclosure of the exact photos that they're going to use. So we can't make a global objection to general photographs they've given us in discovery. They're required under 32.1, well prior to trial, to let us know specifically what evidence they intend to introduce at the trial. And we received this last week in the midst, what was it? What day? I don't recall the day, but in the midst of our mitigation case. We did not have time to look at it or address it. We were able to do that over the weekend, and I am now asking to make those specific objections pursuant to my client's right to effective assistance of counsel to due process and a fair trial under both the United States and Colorado constitutions. If the prosecution had told us when their 32.1 disclosures were due, hey, these are the specific photos that we intend to introduce for these specific people, we would have addressed it much earlier, but they did not. When they told us about the videos, we addressed it timely, as soon as we could after hearing about that. And so we're doing the best that we can within the context of what we're given by the people.
Well, in terms of the 4 videos that I ruled on, that was a couple of months ago. So what about that? You said you have one objection to the modified video?
Well, I would just maintain our objections that we have made with regard to these videos.
Okay. All right. I've ruled on the objection, so I stand by my ruling, and I order the people to modify the videos and the photograph montage for each of I think there was 4 victims that they had intended to introduce the type of evidence on, and I ruled on those, and I ruled based on the case law that was provided by the defense. So to the extent you're just making a record that you're standing by your objections, you're not waiving anything, and I ruled. So tell me about the pictures then that are separate and apart from that evidence that I ruled on.
Your Honor,
What are your objections?
with regard to the photos that the prosecution intends to introduce with regard to Alex Teves,
Yes.
there are 10 photographs in addition to the photograph that was previously introduced at trial. Of those 10 photographs, 5 of them are photographs with Amanda Lindgren Teves. We would argue that this is cumulative, and one of the dangers of unfair prejudice here, in addition to the emotional impact it has on the jury, is that the court will recall that Amanda Lindgren Teves was actually a victim in the theater as well, and the danger of highlighting her repeatedly throughout these photos also can point the jury to improper victim impact of the crime on her, aside from the death of Alex Teves. We think that 1 photograph is sufficient, but 5 is cumulative and unduly prejudicial under 401 and 403. And for the record, I will make all of these objections under Mr. Holmes' rights under the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as the similar provisions of the Colorado Constitution. With regard to A.J. Boyk, the court is aware, having seen the video, that there are 27 photos already on the video itself, and there are 3 video clips as well on the video itself. The people intend to introduce, I think, 3 additional photos that are cumulative and represent similar photographs that are already being played on the video itself. And let me, if I can approach, Your Honor, I have thumbnails of the photos, and I can refer the court specifically to the numbers to make it more clear.
Okay, please. Thank you.
And with regard to is this still working because it's on red? Sounds like it. With regard to the photos for Alex Teves, The numbers are 2655, 4679, 4680, 4682, and 4683.
Okay,
With regard to A.J. Boyk, the photos are 4672, 4673, and 4674.
all right.
With regard to Jessica Gawi, the court will remember that the video is of her doing a sports interview, and we believe that that is cumulative to 4689 and 4686, which also depict her in that same type of work environment. With regard to Jonathan Blunk, there are 6 different photographs of Mr. Blunk in various combinations with his wife and his children. We believe that 4695, 4696 are cumulative to 4691, 1692. Oh, actually, that might be 4692, 4693, and 4694. In addition, in 4697, there's a grouping of photos, like sort of a poster montage of photos. We object to that presentation of the photographs and believe that they're cumulative to the previous photos. And specifically, there's also photograph 4698, which is at his gravesite with his wife and 2 children. We object to that as unduly prejudicial. With regard to Matthew McQuinn, there are 2 photographs, 4702 and 4703, one of which is of his headstone, and I believe the other is of his casket.
Tell me those numbers again.
4702 and 4703. Additionally, Your Honor,
And what's the objection on those two?
403, we believe that they're unduly prejudicial, as well as the constitutional provisions I previously stated. And it's not victim impact. In addition, there are 3 separate photographs of him with his, actually 4 of him with his girlfriend, and that's 4699, 4705, 4706, and 4707. We believe to present all 4 of those would be cumulative. With regard to Gordon Cowden, the court is aware that the video for Mr. Cowden consists of, at this point, 29 photos. It is unclear how old some of the photos are, but we believe that the photographs contained in the video are cumulative of photos 4914 as well as 4718. With regard to Jesse Childress, we would inquire as to how old the photographs are. It's not easy for us to tell. And I know that the court has limited the people to photographs no more than 18 months old, dating back from July 20th of 2012. And the photos, I think, that I'm unclear on are 4719, 4720, 4721, 4722, and 4723. And with regard to Veronica Mosier Sullivan, we believe that 4732 is cumulative to the other photos, 4730 and 4731. And we also object to 4851. This is a photograph of her gravestone.
Hold on. Okay. What else?
4851 is a photograph of her gravestone, and like the other photographs of grave sites or gravestones or caskets that we've objected to. We don't believe that it is appropriate as victim impact evidence. We object under 401 and 403, as well as the constitutional provisions I previously mentioned.
Anything else?
Your Honor, we would ask to mark, I have another copy of the photo thumbnails as a court exhibit, as well as a copy of the disc that contains the victim impact videos. It also has the photos on there, but I think it's important to have the videos as they relate to the cumulative or 403 objections that we made in combination with the photographs.
Okay.
So I don't know what court exhibit number we're on.
If I may, Your Honor, I had a couple of court exhibits that I've already marked that I was going to ask to present to the court.
Okay.
And, I mean, I could renumber them, but I have 113 and 114, which I think are the next two pre-marked, and I was going to, after we were done with this, was going to ask to do that. So if I would just ask they start with 115 with these.
All right, why don't you do 115 for the photographs, for the thumbnail, and 116 for the disc. So the disc just contains the evidence that I reviewed before that I ruled on, right? The videos, the montage, and
These are the videos that were modified as a result of the court's orders. So I don't think you've seen these exact ones, but yes, they're very similar to what the court has seen.
all right, thank you. All right, people's response.
Thank you, Your Honor. Your Honor, as to their objections to the photographs of Alex Teves with Amanda Lindgren, the people aren't presenting 5 photographs to show cumulative effect of their relationship. They all represent different events in the victim's life, and the victim impact evidence is supposed to give a glimpse of a victim's life, and that's what those photographs do. So the people would ask to be able to present all 5 of those photographs to the jury, even though they do have Amanda Teves and Alex Teves together. However, the defendant presented over 50 photographs of his family, and multiple photographs of his family, showed him with his parents, showed him with his sister. And so the people don't believe that that's cumulative. They show different moments in a person's life.
Again, remember, comparisons to mitigation evidence, not very persuasive with me. I know you folks keep doing that, and perhaps it feels unfair to you, but that's not the law. So it's not an apples to oranges comparison, but I understand your point. Now, remind me, with respect to Amanda, what injuries, if any, did she incur?
She incurred slight injuries, Your Honor.
Okay, all right, next.
And Your Honor, just for the record to reflect, I understand the court's position, but our point is that under Payne at Site 825, we are supposed to be able to rebut mitigation.
I completely understand, but the rules don't apply the same. You know that's the case. Mitigation rules are not the same as victim impact evidence rules. So,
Your Honor, as to A.J. Boyk's, the additional photographs, they are not all cumulative. One of the pictures is with his brother, and there are no other photographs of A.J. Boyk with his brother in the video that the people were going to introduce.
okay, what about the other two?
As to Jessica Gowie, again...
Oh, hold on. There were 3 photos that the defense is objecting to with respect to A.J. Boyk, 4672, 4673, and 4674. And you said one of those is with his brother, right?
Right, and Your Honor, they didn't give me a copy of their thumbnails, and so it's hard for me to know what these other 2 photographs were from memory.
Here, why don't you take my
thank
copy?
you.
Great, thank you. It's 4672, 4673, and 4674.
So, Your Honor, the people would concede that there's lots of photographs with Los Samoa and A.J. Boyk in 4672 and 4674, so we would agree to not admit those 2.
Okay, so 4672 is out by agreement, and 4674 is out by agreement, and then that leaves 4673?
Which is the picture with his brother.
Okay. All right, and you said that's the only one you have,
Correct, Your Honor.
including in the other, the disc that I reviewed?
Correct, Your Honor.
Okay. What else?
Your Honor, as to their objections to Jessica Gowie's sports interview questions or interview photographs, the people would submit that they were different moments of her career that was burgeoning, and that is part of the sad impact of her murder, was that she had a very successful and promising sportscaster career. So we would ask to still be able to admit those photographs because they depict different points of her internships and the careers that she had at the moment.
All right, Jonathan Blanc?
Again, Your Honor, these are pictures of his family and his children. He was murdered and left two very young, small children, and that's the impact. And again, these pictures are not just to show that he had a family, but they are to show the different moments in the family's life. And they also depict what kind of father he was. They show different events that he's doing with the children. And so it's not being offered for the cumulative effect of the family members, but the different moments in his life.
And what about 4698, which is apparently a picture of his family at his gravesite?
And Your Honor, the people would submit that all they have left, all of those little kids have left of their dad is a tombstone. And they go there once a year to honor their father. And that's absolutely an impact of the murders on their lives.
Does the case law allows pictures of gravesites?
It does, Your Honor, and it was cited in the people's pleading to the court.
Right, okay, what else?
And that they had also had objections to the grouping of photographs of Chantal Blanc, and the people would stipulate that we would remove that one photograph.
4697?
Correct, Your Honor.
Okay, so 4697 is out by agreement. Are there any other pictures of Jonathan Blanc in the disc that I reviewed? There are not, correct? Are there pictures of Jonathan Blanc?
You didn't review a video of Jonathan Blanc.
Okay. Are there any pictures in there, or is it just a video?
There are pictures of Jonathan Blanc. The people only intend to introduce photographs of Jonathan Blanc. We don't have a video for him.
Okay, and how many photographs are there total?
Let me look at my pleading, Your Honor. I cited it to the court.
Your Honor, there are 9. That includes the photo that was previously introduced in the merits phase.
So 9, not including the thumbnail photos that we're talking about.
And Your Honor, the people think it's 7 photographs that we're total intending to introduce after taking out the photo montage.
So you're not intending to introduce the photo montage?
No, Your Honor.
Okay, so then 7 total. That would be 4695, 4696, 4691, 4692, 4693, 4694, and 4698.
Correct.
And does that include the one admitted during the trial?
It does.
Okay, so 7 total. All right?
Your Honor, that, my count is different. I have 4855 as an additional photograph for him, but I could have that wrong.
That's the one that we introduced in trial, Your Honor.
So then it would be 8.
I apologize.
That's okay. All right, what about Matt McQuinn?
People would make the same record about that there's case law that says that pictures of caskets and headstones is permissible and it's part of the impact of someone's murder. And as to their objections about cumulative photographs of Samantha Yowler and Matt McQuinn, again, we're not trying to introduce cumulative photographs of their relationship, but it's rather the different moments that they shared that were part of Matt McQuinn's life.
And so, and how many photos are you intending to introduce of him?
Sorry, Your Honor, let me try to find my pleading and...
He wasn't included in the disc, correct?
Correct, Your Honor.
All right. What about Gordon Cowden? It sounds like there are 29 photos in the montage, and now there are additional ones to the 29?
There were some additional moments of the family that did not make it into the photo montage, and the people would ask to submit those additional photographs, but we would agree to take out the photographs 4914 and 4718 that the defense asked us to take out.
Okay, those are out. and then Jesse Childress.
And Your Honor, as to the defense's point, the court actually never made a ruling that the people had to not have just photographs of victims within the last 18 months of their life. The court ruled that we had to have in the videos that those had to be within the last 18 months of the victim's life. But I specifically inquired about this of the court, and you said that you wanted to see what happened in trial before you made that ruling and that you couldn't make it in a vacuum. So in terms of her requirement that I tell her how old the victim was in all of those photographs, that was something that the court had not ordered the people to do previously. And so we would ask that those few pictures of Jesse Childress's life, which basically depict the last 5 years of his life, frankly, be admissible, Your Honor, as we're not showing baby pictures, we're not showing pictures of when he was very young. It's just his initial entry of his career in the military and where he was based abroad.
And how old was he when he died?
He was 29 years old.
And so all the pictures are between 24 and 29?
I believe so, Your Honor, and I could verify that.
And you said this is because you want to show him in the military,
His career in the military.
his career in the military? Do you have any military pictures that are closer to the time of death?
I don't have any military pictures closer to the time of death.
Was he still in the military at the time of the shooting?
Yes, Your Honor.
All right, and then finally Veronica Mosher Sullivan.
And Your Honor, the people would state that the picture of her gravestone make the same record that we made for the other victims.
All right, thank you. I'll take these under advisement, and I'll give you a ruling tomorrow morning. Is there anything else we need to talk about at this time before we adjourn, finally, for the day? Mr. Orman?
A couple of very brief things, Your Honor. And I'm not asking for an answer on this first one, but had Your Honor given any thought to the amount of time it was going to give the parties for closing arguments in Phase 3?
Not yet. Actually, I did give it some thought. I had given it some thought, Mr. Orman. I'll tell you my initial thoughts, but I haven't made a final decision because I want your input. My thought was that I would give each side 40 minutes in the initial closing and 20 minutes for rebuttal, if there is rebuttal, for a total of 60 minutes. Each side gets a rebuttal if it's appropriate, with the prosecution going first and the defense going last.
Certainly that's sufficient, Your Honor. It's probably, well, it is more than I think we need. I think the jury's probably heard enough attorneys talking to them. So if the court wanted to give us less time, we'd be okay with that as well.
Ms. Brady, how does 40 minutes and 20 minutes sound?
Fine.
Fine? Okay. Let's stick with that then, 40 and 20. You don't have to use all of it, obviously. All right. Anything else, Mr. Orman?
Your Honor, I have two items I would like to present to the court as court exhibits. One is C-TR-113, which is disc containing the PowerPoint slides that Mr. Brockler used in his closing in Phase 2. The other is C-TR-114, which is video that we captured that shows this part of the courtroom, the front of the gallery, during the disruption that we had last Thursday, but captures, I think, in some regard at least, the audio of the disruption and the reactions of the people in front of the bar when that occurred. So if I can just present those to the court so they can be part of the record.
Yes.
And I have copies for counsel.
Great. Thank you. Anything else, Mr. Orman?
No, Your Honor.
All right. Anything from the defense? Ms. Brady, do you have anything before we adjourn? Yes.
I did that wrong.
Oh, no, perfect, thank you. I don't know why I wrote that. I wrote the wrong thing. Oh.
Don't have a sticker.
Okay.
You need
Here,
a sticker.
there you go.
There's no
It
sticker.
says written there, that's all.
Your Honor, if I can inquire as to whether the PowerPoint from Mr. Brockler's closing at Phase 2, if we have both the PowerPoint that we objected to and I made my record regarding in addition to the final PowerPoint that he actually used. If we could have both of those on the record, please.
First one was presented in printed format. I don't know why we would need both in a electronic format. So I was just given this and asked to present it to the court. I didn't create it or have anything to do with that.
Okay, why don't you talk to Mr. Brockler about it tomorrow and see what is contained in that disk and whether any additional record needs to be made. And if there's not a disk of the initial presentation, perhaps he has paper copies, or we can make paper copies part of the record, okay? Is there anything else? All right, thank you, folks. I'll see you tomorrow morning. Let's have the attorneys here at 9:30. I'll give you a ruling on the outstanding issues. There shouldn't be that much. Actually, let's have you come in at 9 just to be safe. Better that we wait, not that the jury wait. Let's have you in at 9. I'll give you rulings on the outstanding issues, and then we'll have the instructions done by then, the introductory instructions, and we'll have copies made for you and for the jurors.
I was going to suggest 7:15, but that's fine with me, Your Honor.
You can be here at 7:15 if you like, Mr. Orman. All right, thank you, folks. I'll see you tomorrow morning. The court will be in recess. Thanks.